reason why. And that then feeds into the cost consequences of failing to engage. That's all beforehand. During the case, equally, you have an obligation every now and again to remind them about this. It's not a statutory obligation, this is under the law of negligence. I trained in Coakley Maloney and Flynn, as it was then called in Cork. It's now called Coakley Maloney. A very, very good firm. However, a couple of years ago there was a judgment where Nicky Kerrins pronounced that they had been negligent. And a particular partner in the firm had a client who had his own inflated ideas of what the case was worth, couldn't even get a certain renowned, quote, forensic accountant, unquote, to say that he had a claim in the stratosphere of figures that the client wanted. And the solicitor in Coakley Maloney had written a couple of times to say, listen, if you don't get this on, the other side are going to move to strike the case out for want of prosecution. It happened. Motion in, skin of the teeth. They got out on it just about. Again, another letter. Now you really need to focus. You need to get an expert report. We need to get this case on for hearing. If you don't, if they come again, next time you won't get out of it. Again, doing the rounds, couldn't get somebody to swear up. Motion to dismiss, on advice of counsel, settled for small money, then turns around and sued Coakley Maloney. Now imagine the scenario where Nicky Kerrins is giving his judgment to the High Court and he says, I'm satisfied that the solicitors were negligent. They didn't write often enough, repeatedly enough, and in clear enough terms to this particular client to advise what needed to be done. So you can imagine the partners collectively down the back going, even though they were insured. But then he pulled them out of the frying pan and he said, however, in the case of this particular client, and I paraphrase, he's a nutter, he wouldn't have listened to you anyway. So there was no damage done. You were negligent, but he didn't actually suffer any damage. Because even if you written to him every day, he wouldn't have listened to you. Collective sigh of relief. It's under appeal. Emerald Island versus Coakley Maloney, if you want to look it up. So you have an obligation to repeat often and regularly. So as things, if you're getting ready for trial, the defence is in, you're getting ready for trial, you need to advise again about the advantages and benefits, etc. The court's role, the court can invite people to consider mediation as an option, they can adjourn, they can make orders extending time for compliance with rules, they can make any order they think will facilitate the process. If somebody wants to apply to stall the ball and say, Judge, we'd like to go to mediation, will you adjourn please to facilitate that process? You must do it at least 14 days before the case is listed for hearing. Now, remember, parties' conduct under the Act can be taken into account. I have a case with a firm in Cork where 2016 I invited them to consider mediation, silence. And silence in response to an offer to mediate or to negotiate can be regarded as unreasonable with cost consequences. The day of hearing on the appeal, now we won the case. I was for the defendant. We won it, but the judge, the circuit court judge in his wisdom decided, not going to make things worse by making a costs order. It was a particularly involved case, very complicated. We appealed it. The day before the appeal came on in for hearing in December, the other side said, all right, so we'll mediate. And they asked the judge to adjourn it to mediate. We spent 6 weeks agreeing a mediator, and every time a date was suggested for the mediation, they said, the date is not suitable. And I have about 8 letters to them saying, not suitable for whom, and not suitable why. Is it you, the firm, a large firm of solicitors with many solicitors? There's me with, at the moment we have 3 solicitors in the practice. You've got 10 times and more of that, so work out which firm it's likely to be. And the 8 letters, they haven't identified for whom any date is unsuitable. It came back on again in the list at the beginning of last month, and again they applied for another adjournment. And we said, okay, we've identified a date, we have the mediator, we want you to, I know at this stage there's a separate set of proceedings in being between the parties as well. And we said, we will agree to adjourn it on the basis that you agree to mediate with the mediator who's agreed on a certain date, and all matters between the parties, not just the previous proceedings, but these fresh ones as well, and you undertake to the court on that basis. They applied following that correspondence, and we said, on the terms as outlined in the correspondence, we would agree. They didn't say we undertake on those terms, but they got the adjournment. Lo and behold, we still can't agree a date, because they keep saying it's not suitable. Win, lose or draw, it's going to be the test case, I think, in the High Court in terms of parties' reasonableness and engagement with the process. So watch this space. I might be lecturing about the costs next year. Mediators report to court. Unlike the MUDS Act, the mediators report only, remember now, in cases that come out of court and are going back to court. A mediator's report doesn't get the point of fingers under a 2017 Act. Under the MUDS Act, you do get the point of fingers. And the report must say, if the mediation took place, great. If it didn't, why didn't it take place? If it did, was there a settlement? And if so, give the headlines of what the settlement was. Limitation period, I've already explained. Once it starts, once the agreement to mediate is signed, the limitation clock stops and starts again when the mediation agreement or the mediation settlement is signed or the mediation is terminated, and the mediator has to inform people in writing as to when that is. Costs and fees share equally unless otherwise agreed. Fees must be reasonable and proportionate, and I gave you the example of the refund. Award of costs. A court may have regard to any unreasonable refusal or failure by a party to consider mediation. Now, I'm not going to have time to go through the case law. You can go through it yourself. There's 100 slides there encompassing every case in Ireland, England, Canada and Hong Kong on the costs issues. But the basic thing is that even if somebody believes they're right, if the court takes the view that they were unreasonable and they were playing silly buggers, they can be refused their costs if they win, and even if they win in exceptional circumstances, they can be made pay the other side's costs. That's all under the legislation. The final provisions of the Act provide for various amendments to rules. The district court rules are the most comprehensive, even though it's the forum where there's least likely to be mediation. They're actually, that's down to Rosemary Horgan, our former colleague. They're the most comprehensive. They include the precedent statutory declaration, the circuit court rules and the high court rules don't. Definitions, very much the same. They mirror it, but it's tied in with the references to the court rules, the particular court rules you need to do, grounding on motion under Order 44, etc. Mediator's report, it's not in the Act, it is in the rules. The mediator's report must be produced to the court by means of an affidavit in the title of the proceedings, exhibiting and verifying the report. In other words, this is my report, I'm swearing that this is true, what is documented in the report. The difficulty for the mediators community with these rules is that under the rules, any party who has sworn any affidavit in any proceedings can be served with a notice to cross-examine. So somebody decides the other side were cynical. They went to mediation to delay it, they were trying to put a fast one, they only wanted to be able to be seen to tick the box. I now want to cross-examine the mediator, so the mediator would give it evidence as to what somebody did. That they came in, took off the watch and played sulky puss for 2 hours, or whatever. Section 10 says everything is confidential. The agreement to mediate says everything is confidential. But somebody has a right to cross-examine you. Will a judge even allow it? I don't know. But it's a scenario that can happen. Murphy's Law, anything can go wrong at will. But have you heard John Gallivan's commentary on Murphy's Law? Murphy was like an optimist. Anyway, adjournment to facilitate agreed orders, extension time for compliance, etc. It's all in there, in the rules, reflected in the rules as well as the Act. The actual format of the declaration, this is it. I haven't advised my client. Now, by all means, when you're doing the statutory declaration, if you want to, include exhibits, the pack that I give out, but do not exhibit your letter of advices, because the other side can look at it. And you may be saying, actually, the reason you should mediate is because you have no claim. And if you go to court, the judge will throw you out. But if you go and mediate, we might be able to negotiate the problem. Don't exhibit that letter. Don't lodge it in court where the other side can see it. I have provided my client with the information, and it's names, plural, addresses, plural. You need more than my pack. The advantages, etc. Sworn, etc. And that's all in there. Circuit court rules, they reflect the same thing. Family law rules, the only thing about the solicitor's certificate, all that fuzzy-wuzzy counselling and stuff, yeah, I told you about that. That's now a statutory declaration, not just a solicitor's certificate. I've done up a checklist, a 10-step checklist. That's in the pack of stuff that'll get you as well. And that sets out a checklist. If you tick all the 10, you've covered your proverbial. Costs, again, the court, any court, considering the costs, can have regard to the matters set out in section 21. Parties' conduct. And it's an objective assessment of a party's subjective position. Subjectively, someone may feel, I'm perfectly entitled to say no, I'm perfectly right. And there have been a couple of cases. There's one of the cases was a partnership case where somebody said, there's no point in us mediating a partnership dispute, the guy's a nutter, I paraphrase. The court, having heard the evidence And I paraphrased, said, yeah, you're right, he was a nutter, and nothing would have been achieved going to mediation. Therefore, we're not going to penalise you. Normal ordinary costs apply. That's the 10-step checklist, etc. Now, how many people here are familiar with Cassandra? You're familiar with Cassandra, yeah? A friend of Galvin's. Basically, Apollo, Greek god, had the hots for Cassandra, decided to butter her up and charm her, gave her a gift. He gave her the gift of prophecy. The only problem was she didn't reciprocate in her affections. He got pissed off. He couldn't take back the gift of prophecy, and there's various descriptions, depending on which branch of mythology you read about as to how he did all of this. But he took a twist on the gift, and he damned her never to be believed. She foretold the fall of Troy, but she wasn't believed as to what was going to happen with the old horse we brought in the walls. I feel at times when I prophesy things that I'm Cassandra. But I'm telling you now, some solicitor is going to get crucified. In the same way that some poor unfortunate junior solicitor, raw out of Blackhall Place, got hauled up in front of Peter Kelly over the swearing of an affidavit last year, some solicitor is going to end up on the wrong end of a judgment in relation to costs, and you don't want it to be you. So follow the procedures that I've outlined, get the client to sign off and stuff, and that should get you out of jail when it comes to the question of the wrong end of an order of costs. This is the attitude of the courts. We're now at 12:30. If you want, I can give you a 10-minute thing on the costs. If not, if you're all desperate for a drink or a cup of coffee at this stage, we can go on. I won't be offended if you say you had enough of me after 2 hours. Who wants to go ahead? Silent nods. Okay, we'll take the silent. Actually, there's diagonal nods. It's kind of hedging your bets, yes and no. I'll give you a 10-minute version. Basically, you can read through these in your own time. And the issue is, if there's an escalation clause, if somebody commits, or they make a policy of saying, oh, public, oh, we love mediation, we'll go there, and they don't, and they go to litigation, it can be held liable. Local authorities are the worst for doing that, and there's lots of case law on that, that you could, if they rush into court, you can say, stop the lights. I've got a case, client committee on Monday, planning injunction by the local authority, and we're going to see if they'll go to mediation. They'll probably say no, but we're going to bring a motion to do it anyway. Basically, all of these cases, every case turns on its own facts, and you have to look at the question of whether or not somebody was justified in refusing to engage, or how they behaved. But it's an objective assessment by the court of a party's subjective belief. That's the one I mentioned earlier, Hurst and Leeming, the partnership case where there was the nutter involved. Well, like the Scotland Government Department said, oh, we love to go to mediation. They went straight to court, denied costs. Again, somebody who pulled out for mediation just before hearing, denied costs. There's a couple of important cases I'll briefly mention. Halsey. And this was one where the court said everybody should know about mediation at this stage. But it identified 6 factors that will be taken into account by the court in considering the costs implications. One is the nature of the dispute. And I've often said there's nothing so simple a lawyer can't make it complicated, but equally there's nothing so simple a mediator can't uncomplicate it. The example I give about a lawyer complicating something. If a doctor is treating another doctor, who decides on the treatment plan? How would a lawyer express that? If a doctor is doctoring another doctor, does the doctor doing the doctoring? Doctor, the doctor, she's doctoring, the manner she, the doctor is doing the doctoring, doctor, the doctor, she's being doctoring, the manner she, the doctor is doing the doctoring, which the doctor is being doctored to be doctored. I'll need a paragraph B. Does the doctor is being doctored, that's the doctor is doing the doctor, the doctor is being doctored, the doctor is being doctored, the manner in which she, the doctor is being doctored, which is to be doctored by the doctor is doing the doctor. Anyway, tongue twister. Halsey, parties' beliefs. Some people believe they're right all the time. They might not be right all the time. Okay, and there will be an objective assessment. The parties themselves are not the arbitrator of whether their conduct is reasonable. Whether other settlement agreements or methods have been tried. Have you tried face-to-face negotiations? Have you tried conciliation? Have you tried something? If you have, you won't necessarily be penalised for not going to mediation. If the costs would be disproportionately high, a perfect example, and I shouldn't keep doing my left arm, the €6,000 island for the kitchen. The bathroom extension, or the new bathtub, the €6,000 starlet or whatever, the costs might be disproportionately high in those circumstances. Delay to a trial date, particularly relevant outside Dublin. It's all very well in Dublin, where the courts are saying all the time, in fact every Monday. But outside of Dublin, I don't know whether you know this or not, for example, circuit court judges don't sit on a Monday. All the Dublin circuit court judges have to sit on a Monday, causing grievance between the Dublin and non-Dublin judges. But anyway, You know, High Court comes on circuit. You delay, you miss a circuit, you miss 6 months. That kind of prejudicial thing could be taken into account. Whether it had a reasonable prospect of success, and again, this is an objective assessment. The courts have taken the view, really, there's nothing so intractable, unless it's a point of law or something that just cannot be settled, that has to go to court. There's nothing, no reason why it shouldn't be mediated. Other factors, Part 36 offers, that's like tenders, call to banks, etc. That's another lecture for another day. A request should not be ignored. If you lay down your paper trail and you repeatedly, when you serve the proceedings, when you serve your statement of claim, when you get the reply to, or you give the reply to defence or whatever it is, you repeatedly invite somebody to mediate or just meet in the courthouse for a chat or whatever, and they either are silent or they refuse, all of that can build up a defence for you in terms of costs if you actually lose at the end of the day as the plaintiff. These are all variations on a theme in terms of the same thing. It's the question of looking at the circumstances of each case. Was somebody's conduct reasonable? And if you're really interested, you can go online and check out all of these cases. But they're all muchness in terms of it. And there's lots of judicial endorsement for mediation, lots of judicial criticism of the parties who didn't get involved, lots of judicial criticism of the lawyers who didn't advise, lots of judicial criticism for lawyers who behaved unreasonably in response to requests. So you've got to be careful. You do not want to be the person who gets crucified on the wrong end of the costs of this. I'm getting towards the end of it. At this stage, I will just flick through these, and you can, as I say, cure your insomnia by going through the 100 slides on costs at some other night. But after all that, is there anybody who's brave enough after 2.5 hours to ask a question? Going once?
Yeah.
Going twice?
I'm here.
Oh, sorry.
Just wondering, in what circumstances might somebody decide not to have the mediation legally binding?
Oh, it could be that there's some circumstances that they don't want the thing to actually be legally binding between them. They agree that it's essentially a handshake deal between them. I haven't had a mediation where that has occurred, and this provision is new. Theoretically, you could provide for it beforehand, but statutorily, this is a new provision, so it's new territory since the 1st of January. And I have struggled to try and think of circumstances where people would agree a settlement, but agree it's not to be legally binding. Time will tell, probably will come up with something. Okay, we'll try again. Going once.
Is the statutory declaration, is that part of the pleadings? Does the plaintiff
Yes.
have to give it to the defendant?
Yes. Well, any pleadings are open to inspection anyway, so even if you kind of slip it in quietly, the other side will take a look at it. I've got a case, very quickly, a niece of mine, in a relationship with a guy for 10 years, I forget the wording of the song now, but basically, relationship is over, something about putting it, if you wanted to put a ring in it, I can't remember the song. But they moved in together for a while in her parents' house. He insisted, in lieu of rent and contributing to the being fed and the washing done and the earning done, to paying fees for a master's for her. She did the master's. They were together again for about 2 years after that. He then left. The relationship was on, the relationship was off, it was off for 3 years. He's now suing her, claiming that he paid the fees on the basis that when she started work, which was 5 years ago, she would start repaying the fees to him. Her parents and the niece are all saying, no, we shook hands on it, that he insisted on paying the fees, and we said, well, fine, then you don't have to contribute anything to the meals, the washing, the earning, whatever. Why then, if she was to start paying when she started work, did you wait until after the she said, it's all off, don't contact me again, to start saying, oh, but we agreed and you were to start paying me 3 years ago? No, it's a family law district court type of claim. But I've said we should mediate it, because you can imagine waving to a DJ and he hears all this. And I've had to issue proceedings on behalf of the parents against him, basically reciting the entire claim in his proceedings against her, and saying there was this deal and there's a counterclaim and there's a set-off, and between a three-party set-off, it's straight 1-to-1. But in front of a DJ would say, look, for God's sake, we just come and talk about it, you know. But they haven't filed they're talking about going to court, and they actually served a motion, but I've checked already, they haven't put in the declaration. So I can now go back and say, nah, you can't have a motion because it didn't put in the declaration. Now they can cure that fairly quickly. But you know, they're determined to try and get to court for some reason. I've said mediation. Who knows how it'll end up in a fallout, Jerry? Who knows how it'll turn out on a fallout? But costs, it's set that even if we lose, the judge might say, well, you should have mediated this. I'm not going to give you your costs.
I remain somewhat unconvinced
No, really?
in relation to the question of costs,
Yeah.
because for years we've been told, you know, that arbitration or mediation is a huge cost saver, it's efficient, and it ticks all sorts of boxes as to why you can resolve things, close that awful file sooner, and it'll cost a lot less. Whereas the experience for those who have occasionally dabbled in the area find that in fact it's more complex, it's another greater layer of bureaucracy and litigation, and it can be very, very expensive as well at the end of the day. And you know, tell me, why is it any different to the parties simply meeting on a without prejudice basis to try and thrash out, and if it takes a day to do it, it takes a day to do it in a complex case, but why not meet on a without prejudice basis and try to meet? Why would you recommend mediation?
It's horses for courses. If you can negotiate it without the assistance of a mediator, great. Because mediation is only a form of settlement, it's a settlement methodology.
That's my view.
But there
It's
are...
an expensive one.
Well, it depends. Certainly now if you're going to get one of the glass palace firms to do it, right? But like my standard fee for mediation was about $3,000 max.
But I had a Toyota Starlet case, which I recommended to that, you know, collar should be issued, and should be a lodgement should be made, and that would be the end of it, because there was no more in district court jurisdiction, and it ended up costing over 100,000 in costs because they didn't want to lose face, you know. But you know, and the costs were crazy.
But again, but you wouldn't know starting off a €6,000 Starlet case that someone, for the sake of it, like the garage who tried to challenge my arbitration award, is going to go all the way. But there's a number of elements to your question. It depends on the case. It may be that the parties can't actually talk to each other. I had one case where literally the parties couldn't talk to each other, but we successfully mediated it. But there was no prospect of them negotiating it between themselves. Again, particular circumstances. I even had a case where I was asked to mediate a top and bottom apartment problem with transmission and noise. Apartment upstairs put in a wooden floor. Child drives the bike backwards and forwards with a drum effect coming down stairs. And I wasn't fully briefed by the apartment management company who asked me to mediate, but there was a history. I started off with the group hug. Now there's only 2 wives, 2 husbands and myself, and we had no table, we just literally a circle of 5 chairs. And I was asked to explain the rules, and you listen very carefully to what somebody is saying. Husband 1 up, bop, punches the lights out of husband 2. Now, having separated them, put them in separate rooms, we found out the reason was he wasn't giving the wife number 1 the evil eye while she was speaking. He was doing what I asked him to do, which was to listen very carefully to what someone was saying, note what they were saying, and come back at it. And the socio-demographic grouping from which the people were drawn in Dublin, if I can put it this way, on the north side of Dublin, it's perfectly acceptable if someone gives their wife the evil eye to knock their lights out. And we successfully mediated that one, right? But that's managing the emotions as part of the process. Arbitration. Arbitration has a dirty name, and it is because arbitrators don't control the process. I am quite proud of the fact.
Charge or not, and very often make a bags of the order at the end of the day, and you end up.
Well, I was about to say, I am proud of my record as an arbitrator, in that over 90% of the arbitrations which I've acted have never gone for a hearing. Because I get people in, and I ensure there's a full exchange, there's no surprises, there's engagement between experts, and everyone knows what's at stake ever before it gets to a hearing. Now, in one sense, I'm doing myself out of prolonged hearing fees. On the other hand, I prefer people to settle. And arbitrators have a dirty name because they don't manage the process. It invariably ends up with one party screaming at the arbitrator, you know, if you don't get on, we're going to apply to have you removed. And the arbitrators don't case manage it. And as you say, they run up very expensive fees. There's no statutory regulation of fees. The fees have to be reasonable and proportionate. But a colleague in Wexford, who was involved in a mediation, texted me last evening about a mediation in which he was involved, and he said, had I been down to Wexford to give the lecture before he got involved in that particular mediation, he was involved personally in a property investment, he said there was a different mediator. But the mediator from a glass palace firm in Dublin was a 5-figure sum. Now, I have never, ever gone anywhere near a 5-figure sum. I consider it extortion. But that's where some people are going. The senior counsel mediator, there was an insurance company wanted a mediator and wanted a particular senior counsel to do it. And he said, I can get 20 grand a day in the High Court. I want 20 grand to spend my day mediating. Now, I think that's almost immoral. But that's just my personal opinion. That's the Church of Bill. The Church of Senior Counsel don't subscribe to that. Like, if I could develop a career, let's say 2 mediations a week, and I got 3 grand per mediation, that's 6 grand a week, I'd be quite happy travelling from Cork to Donegal once or twice a week for that kind of money, if you think about it. Because it's intense, but it's not rocket science, or as far as Joey and friends used to say, it's not, you didn't say rocket science, it's not rocket surgery. But the fees, there's a scam going along in certain quarters in terms of fees. Certain people are trading on the need for, say, senior counsel to arbitrate, to mediate, to etc. It should be our colleagues. We are equally qualified to deal with negotiations. The School of Life will teach you a lot more than some qualifications. Like, I've got various merit badges as I've described them, but I could be utterly useless. In this room, there are very experienced lawyers who will be well capable of negotiating, arbitrating, litigating, but they may never get off and get the bench.
Well, as you say, it's much about psychology and common sense.
Yes.
We'll have to.
We're going to have to, John's, call him John's.
Yep.
Okay, going, gone. Thank you very much.
Thank you.
The dining room, and if we had people back here near 1:45, as possible, we have a long afternoon. Okay, thank you.